where we are today with the slides. Before I go there, I forgot to deal with two aspects that's not part of my slides that I must deal with, and I'm going to deal with it now. The first one is the mediation. Now, in 2019, I think it's 2019, yes. Oh, no, 2020, just before COVID, the rule actually came into operation, if I remember correctly, on the 9th of March 2020. The Uniform Rule 41, capital A, was inserted, and it deals with the aspect of mediation. Right? Now, in High Court, and now recently, it's also been introduced in the Magistrates Court rules, but I'm not going to talk about the Magistrates Court rules. You've done that already. So mediation, the introduction of Rule 41, capital A of the rules, brought about a new focus on mediation as an alternative method of dispute resolution. So parties are encouraged to look at these alternative methods of dispute resolution. Right? In terms of Rule 41, capital A, parties are now required to contemplate mediation as a possibility of settling the matter before they go into the trial aspect of it, before launching into the trial and litigation proceedings. Now, a mediation, even though I say that, mediation is a voluntary process. It is not compulsory to mediate. What the rule makes compulsory is that the parties must indicate that they have considered the aspect of mediation. It doesn't say they must mediate, but they must indicate that they have at least given it some consideration. Okay, just to look at the rule, let me just look at the rule. It says in every new action or application proceeding, the plaintiff or the applicant shall, together with a summons or combined summons or the notice of motion, serve on each defendant or respondent a notice indicating whether such plaintiff or applicant agrees to or opposes referral of the dispute to mediation. And then similarly, in terms of Rule 41, capital A to B, it is also incumbent on the defendant when it delivers its plea or answering affidavit on behalf of the respondent that they must also indicate either that they accept or reject a referral to mediation. And that must be served upon delivery of either the notice of intention to defend or the notice of intention to oppose. Now, the notice described in the Rule 41A is in terms of Rule 27. It's, sorry, not Rule 27, Form 27 to the Uniform Rules. That is the notice that must be served with your summons or with your notice of intention to defend. It's whether you think that the matter is capable of being settled by way of mediation. The court looked at it and defined the mediation in Rule 41A. The court said it is a voluntary, non-binding, non-prescriptive dispute resolution process. So it's non-binding, and mediation will always be voluntary to be effective. And then there's a whole process that you must do. If the parties are going to opt for the mediation, there's a whole process that they must go through. A mediator must be appointed. The parties will share the costs of the mediator, and the mediator, they will try and then solve the dispute. And if it doesn't get solved, then they can go back to courts. That's basically what it is. Now, I know in some divisions, especially in Gauteng, if you don't have this Form 27, where you indicate whether you are, well, what is your attitude towards mediation. If you don't have that form, you can't open a case file. They don't open a file for you and give you a case number. They are very strict with that. And I've also heard that in other divisions, it's not applied at all. but it is compulsory. Other divisions are probably going to come on board by making it, by being more stricter. Those of you who practice in Gauteng will know about this. Those who are in other divisions, you know that it is not compulsory. Some people has never done it. And also, if it's not done, it can be set aside as an irregular step in terms of Rule 30 of the uniform rules. When we did irregular steps, if a plaintiff or an applicant fails to have the Form 27 where they've indicated their attitude towards possibly just settling the dispute on mediation, if they failed to serve that on you, then you can say that they have committed a irregular step, and you can follow that procedure. Remember, you send them a notice. 10 days after it comes to your attention, you send them a notice. They must then remove it within 10 days. And if they don't within 10 days, you can go back to court to have their proceedings set aside. So that is that. Are there any questions on mediation? Now, like I say, there is no consistency across the board over all the courts, but the rule is there and it is not applied consistently. A matter was already struck from the roll because a party did not comply with Rule 41A. That is the matter of Motswaing versus Mamamule Traditional Authority. It was last year in 2022, where the court upheld a procedural point raised by the appellants regarding the respondent's failure to comply with Rule 41A. The matter was struck from the roll and later re-enrolled after the notices has been served. Okay. Any questions on mediation? And just be aware that you have to file that Form 27 to the uniform rules in terms of Rule 41 capital A. Right. The other aspect that I did not give attention, that I did not discuss with you, and I actually, when I read the comments, I just remembered that I didn't discuss that with you. It's with regards to the fees. Remember I said that when you consult, or I don't know if I said it, but when you consult, you are obviously going to discuss fees. Client is going to ask you how much your services cost, and you're going to tell them, and then you're going to enter into the fee agreement where you're going to estimate the costs of you doing their matter. Right. Now, that is all well. But we also have in South Africa the Contingency Fees Act. That is when a lawyer, when an attorney takes on a case on a no win, no pay, no win, no cost basis, meaning that they take the risk, and when they take the risk of doing the litigation without their clients paying them anything, they take it on the basis that they think it's a very good case and they will get their monies later on. Now, because they take that risk and they enter into an agreement with their client, that the client don't pay anything, they actually fund the whole litigation. And it's done a lot in personal injuries against the road accident fund, and also in medical negligence claims against the government, where the plaintiffs don't have money to institute the litigation. It is expensive because you have to have all these experts and expert reports, and there's a lot of money that has to be spent to bring the case to court. And the attorneys takes this risk, and they sign a contingency fee agreement in terms of the Contingency Fee Act. The Contingency Fee Act is Act 66 of 1997. So if the case is won, only then can the attorney collect its fees, and it collects it from that monies that is paid to the to the plaintiff. Now, the money that is paid to the plaintiff is, they can claim, right, let me just say this correctly. I don't want to say it wrong. They claim either double their normal fee. So if they say to the client, if their normal fee is 2,000 Rand an hour, then they bill, but double that. Or 25% of whatever the matter is settled, whichever is the lesser. So if the matter settles for 10 million Rand, it doesn't mean that the attorney is automatically entitled to 2.5 million. He must send this bill then, and then they must compare it to the, and he's entitled to the lesser of the two amounts and not 25% of whatever is settled for. Matter settles for a lot of money, and that doesn't mean the attorney is entitled to that. It's either double his fee or 25%, whichever is the least. That is for the risk that he took. That is what he can collect for his fees. That is now apart from the other disbursements that must also be paid still by the client. That is now for his fees. Okay, that is the contingency fee agreement. The no win, no pay. So, and if they are unsuccessful with the matter, then the plaintiff doesn't owe the attorney anything. So it's a risk that the plaintiff takes, and he is then paid for taking the risk. He's paid more because he took that risk. Obviously, as the attorney, you would see to it that there are good merits in the case before you make that kind of an investment, because it's time, and you're not going to see your money within a few years. Sometimes matters start. I did the other day that I did a matter that started in 2013. It only was ended in 2023. 10 years later, that attorney is going to see his investment. So that is how long it can take. Are there any questions on contingency fees agreements? None? Yes, Claire. Charlie? You may ask. Unmute yourself.
Thank you so much, Advocate Abrams. It's possible that I could have missed it. Where can you express your attitude towards mediation? Because I understand that you need to send a notice, then after that, the pleadings, if your notice has not been complied with. Do you file it with together with the pleadings?
You file it together. If you are for the plaintiff, you file it together with your summons and your particulars of claim.
Okay, and lastly,
and it's a form 27. It's a form. It's one of the forms to the uniform rule. So you just fill in the gaps where you would say whether you think the matter can be settled through mediation, okay, or if you say you don't think that this matter can be settled through mediation. That's all, and nobody can hold that against you. It's just the court wants you to have considered it. Yes.
Thank you so much. Lastly, your security for cost as the defendant, do you file it also on your, I think it's on your pleadings?
No, you don't plead. You don't have to plead. As soon as possible after you've received summons and that from the sheriff, you can do you send them a notice for security for cost. You don't do anything yet.
Oh, so
because you're saying, yeah, you must show me that you can pay the cost before I defend this matter.
Oh, sorry. So you send a summons as a plaintiff, then is the intention to defend. So when you express your intention to defend, is where you express that you want to see security for cost.
No, that is a notice that you send.
Okay.
It's not in the notice of intention to defend. It is a notice that you want security for cost. Wait, I'm just finding I want to give you the exact wording of the rule. Right, a party entitled and desiring to demand security for cost from another shall, as soon as practical, after the commencement of proceedings, deliver a notice setting forth the grounds upon which such security is claimed and the amount that he is demanding.
Oh, no,
So
it
as
makes
soon as you get the summons, you can first send him a notice. Even you can even do it after the notice of intention to defend. And some people even do it after they've pleaded. But I mean, they say as soon as possible after the commencement of the proceedings. So even before you've done anything as a defendant, you can send this notice.
I follow. Thank you so much, Advocate. I appreciate it.
Yes. Deborah Maunia, can you just mute? Oh, thank you. Okay. Any other questions with regards to those two aspects that I just quickly went over with you now?
Yes, Advocate. Onkgopotse here.
Yes, on
Does the contingency fee apply to all proceedings or specifically to personal claims for damages?
Usually it's in personal injury claims. It assist, but you can also enter into a contingency fee agreement if the claim is based on contract and the client doesn't have money, and you say, okay, whatever you're going to win, you're going to pay me double my fees and or 25% of whatever is the lesser of the two. So it is not just for in terms of the Contingency Fee Act, and it's litigation as such. Let me just see. I don't want to talk nonsense to you. It's any proceedings in or before any court of law. So it's not just personal injury claims. It's used mostly in personal injury claims where the plaintiff doesn't have money to go to a lawyer to go to court. But I mean, in any matter where the attorney feels that he can take that risk, but then they must sign a contingency fee agreement before he starts working. Because for any work done after the signature, before the signature on the contingency fee agreement, you can't include that in the contingency fee. Okay.
All right, thanks.
Okay. Yes, Ms. Bella.
Yes, in the magistrate court practice, Advocate Pitt alluded that with contingency, it does not apply to divorce matters.
Yeah, what is the success going to be in divorce matters?
What if I want to give my attorney the pension share I'm going to receive from husband?
I'm thinking, how could it apply? No win, no fee. Well, this is what I'm looking at the act, and this is what it says. It says proceedings means any proceedings in or before any court of law or any tribunal or functionary having the powers of a court of law or having the power to issue, grant, or recommend the issuing of any license, permit, or any authorization of the performance or any acts. Yeah, it's not barred from that, but I mean, yeah, but I mean, why would an attorney want person's half of the pension from that pension? But I understand. Look, parties get into an agreement. Once the pension pays out, I'm going to pay you my money. But then the lawyer say no. This is what the contingency fee, what the agreement is based on. And the lawyer says no. Why must I take that risk? What? If you're going to pay me, if I have to wait for my money, then I want double my money, or 25%, whichever is the lesser. So I don't know. I don't do divorces, and I don't work at all in the magistrate's court anymore. So I don't know, but that is what I read with proceedings. That is what the act says. So it talks about any proceedings, and it doesn't exclude any proceedings. So maybe they just don't do it in divorces. You don't do a divorce on a no-win, no-fee, because there's not going to be, nobody wins in a divorce. That is actually what I want to say. Do you win in a divorce? Nobody wins. And that's just my I think both lose. But I mean, just look at the act, but the convention is probably then if Advocate Pitt said that they don't apply it in divorces, then the convention is probably that they don't apply it in divorces. You can't take a divorce on contingency fee, on a contingency, on a no win, no pay, because who are you going to say win? Okay, the plaintiff, if they get the divorce, they win. But I mean, if the defendant agrees to the divorce, then do they really? No, I don't want to go into the discussion. I'm talking in circles. I really don't know. That is my answer. Any other questions? None. Somebody also asked the question yesterday about pro bono. I don't know who asked it. I looked on the chat and there was some question about how does pro bono work. Now, with pro bono, the Legal Practice Council expects from each and every legal practitioner to provide certain hours of pro bono work each year. And I don't, attorneys, it depends on the firm and the size of the firm as to how many hours they must provide. I know advocates must provide 20 hours a year to pro bono work. That is now for clients who cannot afford lawyers, where they don't get paid at all. They do it free of charge. And there's a lot of pro bono societies where you could go, where they have attorneys on their lists and they have a kind of a roster system, or you could even phone the Legal Practice Council if you need a pro bono attorney. They can also recommend certain attorneys, or the bar councils for that matter could also refer you. They've got a specific section that deals with pro bono work, where you go and your matter's in the High Court, and they have somebody who is dedicated to doing that, and they will phone up people and ask, we've got a pro bono case, are you willing to do it? Yeah. Any questions around that? None. Okay, so then we move on. Right. I said in the beginning, I'm going to do provisional sentence summons at the later stage, and we have now come to that stage where provisional sentence summons is going to be discussed. You have it on your screens, the screen that I'm sharing, I hope. And Rule 8 of the Uniform Rules deals with provisional sentence summons. And the provisional sentence summons procedure is unique, and it is a hybrid speedy procedure. Now, it's quick, it's different than all the other procedures, and it's a hybrid in the sense that you start out by issuing a summons, but then the defendant files an affidavit. So it's a mixture of the two, of an action and an application. Just can I get an indication you did this with Mr. Pitt, with Advocate Pitt, as you say. You've done this with him. Am I correct? No one says anything. Did you do this?
No, Advocate.
No, Advocate. I don't recall doing this in my
provisional sentence summons. You didn't do it.
Apologies, Counsel.
I didn't pay attention.
Yeah, Counsel, if I may, we didn't do provisional sentence summons, but we did do summary judgment.
Yeah, but we also did summary judgment. Yeah. Oh, okay. So you didn't do provisional sentence summons. Provisional sentence summons and summary judgment are two totally different procedures. Remember, I said you get three kinds of summonses. You get a provisional sentence summons, you get a simple summons, and you get a combined summons. Provisional sentence summons you use if the claim is based on a liquid document, right? Now, I say it's unique and it's hybrid because you're going to see why I say all of that as we go on. So Rule 8 is the one that deals with provisional sentence summons, and you only use this procedure if the claim is based on a liquid document. Now you ask yourself, what is a liquid document? Because if the document on which you base your claim does not comply with the requirements for a liquid document, then you cannot use this procedure. Okay, so a liquid document is a document that's on a proper construction, evidenced only by the terms in the document itself, without resorting to extrinsic evidence. For example, without looking outside of the document for evidence to prove that it is a liquid document. So the document itself must show you I'm a liquid document, right? To personify the document. It must be an unconditional acknowledgement of indebtedness in a certain amount of money, the payment which is due to the creditor. An example of that is a check, like I have there on the slide. Because it's an acknowledgement, it says pay so-and-so 10 Rand, a certain amount of money, it must be paid to that, and it's an unconditional, there's no condition. You don't say pay it on condition that he does X, Y, and Z, you just pay. So a check is an example of a provisional, of a liquid document. There's more examples of liquid documents. And let me just see if your notes have any more examples. Well, it's a check. I don't see in your guideline there are more examples, but other examples of provisionals, of liquid documents would be acknowledgement of debt, a mortgage bond. They say an architecture certificate to which the whole building contract is attached, but that is also a liquid document. A promissory note. I can't think of more, but those are some examples of a liquid document. And any document that complies with the requirements of the definition of a liquid document is a liquid document. And you can only use this procedure if you have that. And now I'm talking to the plaintiffs. So the plaintiff has paid, the defendant paid you, owed you money and paid you with a check, and the check bounced. I don't know if people still use checks these days, but let's say that. Paid you with a check and the check bounced. So now you want to claim. You don't have to go through all the procedures. You use provisional sentence summons. You have the liquid document. Now you must have the original liquid document. Okay, now to the provisional sentence summons, which is form 3 of the uniform rules, you attach a copy of the liquid document, obviously for reasons that the original liquid document might get lost. You don't file that at court, but you keep it and you have it at court so that you can hand it up to the judge to see that I have the original. So you would have a copy attached to the summons, right? Now, you use this, and here is where it gets interesting. The plaintiff who uses this procedure, if he has the liquid document, doesn't have to have anything else to prove their case. Right? And the plaintiff, the onus of proof is his defense is from within the document. You said, pay me this money, but you didn't pay it. The signature is all that can be a dispute. If the defendant should say that signature on the liquid document is not his, then that can be a dispute. Then there would be an onus on the plaintiff to prove that the signature is in fact the signature of the defendant, or if the defendant is a juristic person, of his agent who was properly authorized to do that, to sign it. That is the only thing that the plaintiff must prove. He must have the liquid document. Yes, is there a question? I hear sound. Okay, there's no question. Right. On the defendant can have any of the underlying defenses that is not clear from the document. What are the defenses? When you've signed something, it can be the common law defenses on contract, a duress, undue influence, what is the others? Fraud, misrepresentation. All of those can be part of the defenses that the defendant has to prove that he should not be held liable for what is in that liquid document. Right. So the summons is issued. The defendant files a opposing affidavit. Then the plaintiff files a replying affidavit, and then the matter is enrolled and it is heard in court. Now, if the court grants the provisional sentence. The signature, there's no problems with the signature. Oh, and by the way, the court don't hear oral evidence. The court only entertains oral evidence if the authenticity of the signature on the liquid document is in dispute. If the defendant say, but this is not my signature, then only in that case will the court hear oral evidence. Otherwise, no oral evidence is heard. It's decided on the papers, right? So if provisional sentence is granted, then the defendant must pay. If provisional sentence is not granted, then the defendant can then participate in the case. Then they will go on in the normal way. There will then be a plea filed, a replication. They will have discovery. They will prepare for a normal trial, right? Now, that's the documents that must be in a brief. I don't worry about that. That I've already said. Now, this is what you must pay attention to. Once the court says that the defendant must pay based on that liquid document, then the defendant has 2 months from that date that the court said, from the date of the judgment, to pay. If the 2 months expire and the defendant did not pay, and this is 2 calendar months because the court says 2 months, and the defendant does not pay, then that means then the provisional sentence becomes a final judgment. That is why it's called provisional, because it's provisional until he pays, and if he pays, he can participate also. So he pays provisionally so long the amount that you say is in the liquid document, it says R1 million. I pay you the R1 million. Now I can participate and defend. Then the defendant can also, he pays, he can also claim from the, or demand, not claim, demand from the plaintiff security that that money or something to the value of that money that he has paid or that he's about to pay will be available at the end of the trial. So he pays the money and then he can participate. And if he demands the security, then the plaintiff must grant that security, right? Now you will see that the plaintiff mustn't do a lot. All he needs is the liquid document. He doesn't have to do much more, and he has the Form 3. He goes to court, enters the proceedings, then he can get his judgment if that is so. And the defendant is then barred from defending the matter if he can't pay within 2 months. The advantages of provisional sentence route for the plaintiff is that the onus on the defendant is very strenuous. So, for example, if the claim is for a large sum of money, effectively, provisional sentence will be a final order because the defendant may be unable to make payment to the plaintiff to enter into the principal case. So if the defendant, say if it's a few million rand, it's a mortgage bond, which is also a liquid document. Say it's for a few million rand and the defendant does not have that money to pay within 2 months. Essentially, the plaintiff then has his final judgment. Right. Yeah. So this was challenged as being unconstitutional. They said that it actually bars the defendant access to court in defending an action just because he can't satisfy the provisional sentence order that the court has made. In the case of twee jonge gezellen versus the Land and Agricultural Development Bank or the Land Bank. So twee jonge gezellen, for those of you know, that is a farm in Tilbach who produced that champagne, Kroene champagne. I don't know if they're still in operation, but that is what twee jonge gezellen farm in Tilbach in the Western Cape. They did that. So the facts is still blurry. I know the issues, they're important. I know the ratio dicadendi, but some of the facts is blurry. So just bear with me. I've read it a couple of years ago. Twee jonge gezellen, the farm, took out a loan from Land Bank, right? A few million. I don't know exactly the amount, a few million, right? Then they fell behind in their payments. Land Bank took them to court, and while the litigation was ongoing, they came to an agreement that the twee jonge gezellen entered into a acknowledgement of debt. They signed an acknowledgement of debt, right? They're going to pay, and then that matter was withdrawn, and the acknowledgement of debt was now in place, so they went to pay now monthly whatever they agreed to. Then again, they fell into arrears in terms of that agreement. Now, Land Bank had a liquid document. Land Bank took that liquid document and instituted proceedings in terms of the provisional sentence summons. Then they were successful, Land Bank, because twee jonge gezellen had signed that. They do owe the money, and that's that. There was nothing they could do. The matter went right up until the Constitutional Court, because twee jonge gezellen said, but this is unfair towards us. We don't even get a chance to defend this action. To put our defense up, we want to be given that opportunity. Now, I'm telling you about this rule, so you do know from me telling you about it that the Constitutional Court did not declare it unconstitutional. Otherwise, it would just be a history lesson. So it is not declared unconstitutional, but the Constitutional Court said in twee jonge gezellen that in each and every matter that is brought in terms of provisional sentence summons, the court who is seized with that matter, who listens or hears that matter, must satisfy himself that the only reason why the defendant is denied to defend the action is not because he can't pay. So it is incumbent on a defendant in that case. There's somebody who's on. It is incumbent on the defendant in that case to somebody. Can you just please put yourself off? Right. Where was I? So the defendant, who it is incumbent on him or her to demonstrate in his affidavit that the reason why he is not paying the money is not because it is inconvenient or just because he doesn't want to give them the satisfaction. It is because really he cannot afford it. He must then show the court that he is indigent or unable to pay because of his financial situation, but that he should not be denied a chance to defend the action in court. And only if the court is satisfied of that, then the court won't give provisional sentence summons, and then they will continue as if normal. But if the court, if you have the monies and you just don't want to pay, because remember, if you pay, you can still defend the action. And they must just give security that the money is going to be available. But if you don't pay after 2 months, it's a final judgment. So the court says, if you really don't have the money to pay, then obviously you must demonstrate and give us all the facts and probably proof of how poor you are. And then we won't give provisional sentence summons, but you will still be allowed to enter into the main case, and the case will run as a normal case. Okay, that is provisional sentence summons. Do I have any questions? Seeing that you didn't do it, it forms part of the magistrate's court procedure as well. Are there any questions?
Advocate?
Yes.
You're speaking to Leslie?
Yes, Leslie.
I'm not sure if I'm the only one that's a bit confused, but provisional sentence summons seems a bit similar to summary judgment just because of the fact that they're both based on a liquidated document.
Okay.
Is that correct?
No. First thing, it's not a liquidated document. There's a difference between a liquidated amount of money, that is an amount that is certain or ascertainable. A liquid document is a certain amount, and it's a document. So you can use summary judgment if a claim is based on a liquid document. You can use that procedure as well.
All right.
So remember, and in all cases, you could use a combined summons as well. And for a liquid document, you could even use a simple summons. So you could use any of the proceedings available to you. So go on with your confusion. Just demonstrate to me the confusion.
I would just like to know if you're able, how do I ascertain the difference on when it's a summary judgment, needs to be a summary judgment, or provisional sentence summons?
Well, you can only use the provisional sentence summons if the claim is based on a liquid document. Only in that instance.
So liquid
And
document, not liquidated amount.
No, a liquid document that complies with the requirements of a liquid document. But you could use any of the others as well. But you would use this because it will be quicker.
All right.
And there would be much less effort from your side. But
all right, and liquid document such as a check.
Well, that is an example of a liquid document.
Okay.
I've given you the definition of a liquid document. The amount, it must be an unconditional acknowledgement of debt, indebtedness to the creditor. The amount must be certain and it must be signed by the debtor. The signature must also be on the document.
All right, thank you.
Document. So if it says pay 10 Rand plus interest, that is not a liquid document. Anyone else?
Hi, advocate. I don't know if this is a stupid question, but let's say I've ordered furniture for 500,000 Rand and they deliver, or I paid a deposit and they deliver the furniture and then I don't pay the balance. Would you then add interest to that, or can you only, or do you only sue for the liquid document amount, saying the invoice amount for 500,000?
But is the invoice amount a liquid document? Is that what document is the liquid document? Which document would be the liquid document on which you base your claim?
The invoice.
Is the invoice a liquid document? Did you sign the invoice?
Yes, let's say for this
you don't sign
scenario,
an invoice. Let's not make up facts. You don't sign an invoice. The invoice is sent to you from the creditor. There's no requirement that the debtor must sign an invoice, is there? You don't sign an invoice. You receive an invoice to say this is the services. You sign. I don't know if I have it wrong, but in my experience, nobody signs my invoices except for me when I send it. So the creditor would have signed it, but you as the debtor wouldn't sign an invoice. You would maybe sign an agreement that you entered into, but that agreement would be for the amount and then there would be other costs as well. So it won't be a liquid document. You must look at the document and see whether the document complies with the definition of a liquid document before you can be successful in using that. So an invoice is not signed by and you are not, it is not an unconditional acknowledgement of indebtedness by you to them for that amount that is certain in money, is it? Do you give an instruction on the invoice? You say, please pay, I will pay this amount. There's nothing like that on an invoice. An invoice is just a list of what you've bought with the amount on. I don't know, anybody can jump in and disagree because I'm thinking as I'm speaking.
Okay, no, sorry, I don't know if I'm confused because I just saw a case, Joe Van projects versus ICB property, where they say the invoice would constitute as a liquid document. But yeah, maybe I must just read the case again.
But is the invoice signed? Is that invoice signed by the, because the signature is important. Was that specific invoice?
I'll just go back and check if it was signed.
Sure. Yes, there was another hand.
Sorry, advocate. I just want to say that in my experience, an invoice usually follows a code. A code would be accepted before an invoice is issued. That's my experience. So someone says that I'll do this job for this particular amount and they quote you on it and you say, okay, I accept, this is good enough for me. And then they issue an invoice. So
Who
an
issues the
invoice is preceded by some sort of an acceptance which would have been a quote. So when there's an invoice that is acknowledged between the two parties, for me, that says that that is a liquid document.
And is the invoice signed by the debtor?
Why
Because
would the invoice have to be signed? Because a quote that results to that invoice being issued has already been accepted, and the acceptance therefore is a signature.
I hear what you are saying. My difficulty is just, is that a liquid document? Does it meet the requirements of the definition of a liquid document? You
So
must,
are you saying that?
It says without going to extrinsic evidence.
So are you saying that the signature liquidates a document?
I'm not saying that. Just to see that again.
No, I'm just saying that an invoice usually is issued between two parties that have agreed on a quotation. So you cannot issue an invoice unless someone has agreed on a previous quotation or a pro forma invoice.
Okay, I hear what you're saying. Just look at the definition of a liquid document again. It is under proper construction, evidenced by its terms, by the document's terms, without resort to extrinsic evidence. An unconditional acknowledgement of indebtedness in an ascertained amount of money, the payment of which is due to the creditor. So in an ascertained amount of money would be there, the payment which is due to the creditor would be there, right, in the invoice. Is it an unconditional acknowledgement of indebtedness? You say, then we have to look at the quote. That is not without resort to extrinsic evidence. That is with resort to extrinsic evidence. Is it not?
I agree with you there.
I'm just looking at the definition of what a liquid document is. But like the was it Lavona?
So my point of contestation, advocate, is the fact that an invoice doesn't have to be signed. The quotation has to be signed because the quotation gives birth to an invoice.
I hear you.
The acceptance of a quotation gives birth to an invoice. So maybe if a court applies its mind to that, then that particular definition for me is open to scrutiny.
The court must be persuaded that it is like that. It is for the legal practitioner to apply its mind and to persuade the court why the court should have resort to extrinsic evidence, and then it must still meet the requirements where it is clear from the definition that you don't have to look outside, because you say this is a baby of something else. Now, why must the court look at the parent? You say the quotation is the parent which gives birth to the invoice. So why must the court now look at the mother to see, okay, you are what you say you are?
I'm with you.
I'm just trying to speak in you've used the word.
I'm with you. I'm with you. Don't worry. I'm with you. I'm following you.
Okay. Yeah. Look, yeah, you make good points, and somebody quoted the case, so there might be something in that. I don't know. I don't have all the answers. There might be something in it, but I mean, if you have, I'm going to stick to the definition, and if it doesn't comply with the definition, then I'm going to throw it out as a liquid document. But I mean, it's for us. It's not for the court to apply its mind. It's for us to persuade the court as to how the court should think, and then the court must agree with you. Okay. So you can always try. Yeah. I did a provisional sentence last year. I'm trying to look for it now. I've got it on Caseline. I just want to see, was that an invoice or what was the liquid document? I was sitting as a presiding officer there. Yeah. Just check. Yes, you might.
Advocate Abrams, it's Richard here. You know, the previous speaker spoke about, or my learned colleague spoke about an invoice. You know, a lot of companies are moving away from invoices. And what they use these days is a payment certificate, which is equivalent to an invoice. And there are cases that mainly speak these days about payment certificates, which actually replaces the invoices. And a payment certificate, if the party accepts it, it does not need to be signed. And that is just what I just want to put out there, especially in the construction industry. Thanks.
Okay, I know about payment certificates in the construction industry. That's not necessarily signed. It's for work already done, and then you give a payment certificate on that. Look, I don't want to argue with everyone. I'm just looking at the definition. So there was something that I wanted to say now. You're saying that people are doing, I think in construction they use payment certificates in construction law. But I still use, you invoice people for work done, isn't it? For work that you've done, or for services that you have provided, or for goods that you have delivered. You send the invoice with it. Am I correct?
Yeah, I don't want to go into the details what I do for a living before I get admitted.
What do you do for a living? Now you've made it the whole class curious.
What I'm trying to say is, and the previous speaker said there's a contract between the parties, and invoices gets limited these days, and it works on the payment certificates. If you look at big organizations, constructions and things like that, and there are payment certificates, and when and I don't want to go to another level now, is because if that payment certificate is not on it, they go to the DAB or the dispute resolution avenue. But where it comes in, and maybe they should re-look in the rules of the Rules Commission should maybe look at replacing the word with invoices and have a definition when it comes to invoices, and include payment certificates, because a lot of places make use of payment certificates these days.
And is the payment certificate an acknowledgement of indebtedness? Because I know in my experience that payment certificates, I can still say no, but I don't agree with this and this and this, and then I can send it back. Is that an acknowledgement of indebtedness to that amount?
Then it would go then to the DAB, the Dispute Arbitration Board. Okay. In certain organizations. But the advocate, can I come in? The payment certificate is what the company submits, or this is the invoice. And a lot of big organizations like your Eskom, your Transnets, and those organizations, they do not make use of invoices anymore, and they make use of the payment certificates.
No, I hear you, but yeah, okay, I do hear you, but we are talking about a liquid document. So any document that complies with it, whether it is a payment certificate, whether it is whatever document, if it complies with the requirements and it is a liquid document, then you could use provisional sentence summons. That
Yes,
is
and that's,
basically it.
yeah.
So you could argue that the payment certificate is a liquid document.
And that's
you
why
must
I'm
just
getting
meet
to,
the requirements.
yeah, a payment certificate is a liquid document in my view, not my opinion.
Okay. I got you. There was somebody that wanted to interject.
Advocate, can I just say something? Good evening,
Good
everyone.
evening.
As far as I know, an invoice in all, they like in government, they won't pay your invoice if it's not signed. It's mandatory that you sign your invoice for it to be paid. After that, that's when the payment certificate will come through, that the people who are involved in whatever that you were doing will confirm that that job was done so that your payment may be processed.
Yeah. No, okay. You could argue in court. You could argue that in court. Let's move on. You could argue in court as to why Mr. Ali could argue as to why you think that the payment certificate is a liquid document and he should succeed with, and you could argue the other way that the invoice must be signed, but the invoice is signed by the person who is claiming. Case who said talked about the government. The invoice is signed by me. I send my invoice to you. You must pay me. Then you must give me a payment to say, okay, I did all that work. Now it can be paid. Is that a liquid document? You'll have to convince the court that it is. Okay, so the document must just meet the requirements of a liquid document without resorting to extrinsic evidence. The evidence must be clear from the document itself. You mustn't talk about other documents that could explain why this document is a liquid document. That is the point that I want to carry over.
I think just to close off, Advocate.
Okay.
To me, it's becoming very clear that what liquidates a document is the acceptance of the other party or the acknowledgement of the other party that they are in debt.
Acknowledgement of indebtedness, so, yes.
If I don't think the nature of the document really matters. It could have been a code, it could have been an invoice, it could have been whatever. As long as the other party says that, yes, you have performed, and for your performance, I owe you so much in randellas. And that, for me, should be enough to liquidate a document.
To make a document liquid. No, it is, because an IOU is also a liquid document. If I put on a piece of paper, I owe you 10 Rand, whatever, that's a liquid document. You don't have to look elsewhere to see that all the requirements are met. You just look at the document. Okay. You must,
for me, that matter is settled then.
Yeah. So if you can convince the court that a specific document meets all the requirements without having to look elsewhere, then you can use that procedure. It is quick, because if you owe a large sum of money, like a mortgage bond and that, and you owe a large sum of money, sometimes you won't have the money. But now remember the constitutional challenge, and you have to demonstrate that the court's doors shouldn't be closed for you just because you don't have money. You must demonstrate that in the affidavit. Okay. Right. Applications. We now by applications. So we did actions, and I specifically deals with provisional sentence summons here because I said it's a hybrid, speedy procedure. Hybrid because I said you start with the summons, but then there's affidavits involved. The court doesn't hear oral evidence. The court only hears oral evidence, and Rule 8.7 talks about that. If the authenticity of the signature. So signature is very important for a liquid document. Just read the rule again. And the court will only hear oral evidence if the defendant or disputes the signature. Right, so now applications. We've done the fixed categories and how you determine which procedure to use. We've done it at the beginning of actions. Now you get two kinds of applications. You get an application where there's an applicant and a respondent, and then you get an ex parte application. An ex parte application involves only the applicant and is addressed to the registrar. There is no respondent and no notice is given to a respondent. So application that you are going to bring to be admitted and enrolled as an attorney of the High Court of South Africa is going to be an ex parte application. There's no respondent. Nobody's going to oppose your application to be appointed as an attorney. So that is the ex parte application. Also, the application for the appointment of a curator. That's an ex parte application. There's only one party, right? There's many other ex parte applications where you just alone before the court and you ask the court for something, for relief. It doesn't involve a respondent. Where there is a respondent, then obviously that application is the long form. Sorry, I should have started by saying with an ex parte application, you use the short form, that is form 2 of the uniform rules. And the long form is form 2A. Small a in brackets, that is form 2A. You use that form for the long form, that is where there's a respondent. Now, it makes logical sense why you would use the longer form if there's a respondent, because the form is the form of the notice of motion. With a notice of motion where there's a respondent, you must tell the respondent certain things. You tell the respondent you have so many days in which to file your notice of intention to oppose, to file your answering affidavit, and you must give an address. So there's a lot of more information. That's why you would use the long form. The short form, there's no respondent, only addressed to the registrar of the court, filed at court, only one party. Right. So we looked at the dispute of fact and the Rumeyer case and how you determine what a dispute of fact is. And I also went through this with you, the Plascon-Evans rule. I think you all know it very well now. You don't bother with what the applicant is saying. You look at what the respondent admits and what he says further. And if despite there being a dispute, what the respondent's story is makes it clear that the applicant should ask, the applicant will be successful. That is, in short, the Plascon-Evans right principle. Moving on. So the application procedure, you start with a notice of motion and an affidavit issued by the registrar, the same like in the action, issued by the registrar. Then it is served by the sheriff, exactly the same. The respondent has now, it's no longer 5 days. You must make a correction there. It is now 10 days since last. No, it's this year. 10 days in which to file a notice of intention to oppose. The respondent has 10 days in which to file a notice of intention to oppose. No longer 5 days. Okay. Where there is no notice of intention to oppose, then you set the matter down on the unopposed roll and you get a court date from the registrar, and the matter is then heard in the unopposed motion court. Depending on what division you are, they have various practice directions out on how you set it down and how it is heard. Okay. If there is a notice of intention to oppose, now the notice of intention to oppose is like the notice of intent, it's in that format, but it's notice of intention to oppose because we're dealing with an applicant, but it's the same, and you must also give an address within, and it's now no longer 15 kilometers from the court. Since last month, it is 25 kilometers from the court. All right. So the notice of intention to oppose, and then 15 days after the notice of intention to oppose has been filed, the respondent must file an opposing affidavit. Right? Opposing and answering affidavits are used interchangeably. It's the same document. Then the applicant files a replying affidavit 10 days after, and you are not allowed to file further affidavits. Now, in an application, you must make out in your founding papers your full case. You cannot leave out certain stuff, certain information, and then later on just file an affidavit that contains that information. No. You must make out your full case in your founding papers. If you don't, then you will lose your case. Right, your claim will be dismissed if you don't make out a full case. You cannot tell the court, fill in the gaps in court, because they are not under oath. What is in the papers is said under oath by the deponent of the affidavit. So the legal practitioner can't say, my lord, but this is what should be there, and that is what should be, that is wrong, but it should be this. No, you're not under oath, so it's not evidence. The court can only consider evidence, right? A date is allocated and then the matter is heard. Other heads of argument are usually filed. So the court will already have the facts, the court will have the heads of argument, and then the legal practitioners get an opportunity to orally argue the matter, and the court will ask relevant questions because the court would have read the heads of argument and the papers, and then give an order that it deems to be just in the circumstances. Do I have any questions on that? I'm still going to go into the requirements of the papers, but at this juncture, there's a hand up. Sorry, Janus, I didn't know your hand was up. You can ask.
No, counsel, it's perfectly all right. Yes, regarding an ex parte application. So the ex parte, if you bring an ex parte, do you need to give notice or give sufficient notice?
To who?
Yeah, that's the thing. Just to give you context, I dealt with a spoliation application against a municipality. Previous, the previous handler for road and traffic gave a tender where road humps could be constructed. They were duly constructed. However, during the process, this individual was fired and a new person was hired. The new individual then destroyed the humps. We brought an ex parte application for spoliation, but we had a problem with the judge that said we didn't give notice to the municipality of the spoliation application, which is by nature, I believe, ex parte. So in an ex parte application, is it required to give sufficient notice, or is no notice at all sufficient?
Well, in that case, it is brought ex parte, but there is another party. So it is not in the strict sense like an ex parte where you're going to be admitted or for the appointment of a curator or something like that, because there is another party, and that party, you would find that information in the practice directives. Another party should know that you're bringing an application.
Okay, so in that instance, it would be.
But it's usually done ex parte, and it's usually done. Wasn't it urgently brought?
Yes, it was. It was.
It's usually on an urgent basis. Now, the practice directives say, even if you just before you go to court, even if you just phone them or give them send them an email, you must notify them that you are before court. You're going to go before court. Yeah, that is with urgent applications. I'm not saying that is with spoliation, because I'm not sure if it is applicable to spoliation that you have to let them know before and that you're going to court for a spoliation order. That is the rule with urgent applications, where there must be notice that you're going to court. So anybody else that want to come in here with spoliation that maybe knows more about spoliation, that has done one recently? Spoliation is to restore the status quo ante, the things as it were before, for those of you who knows, and you don't have to own the stuff, you must just be in possession. In undisturbed possession.
An example would be, for instance, when one is renting and you fall behind with your rent and the landlord just shuts off your water and electricity, then one brings a spoliation application. To have it restored. But was it the sufficient notice? Okay, the municipality must give sufficient notice that they're going to do that before they do it. Yes. So, and the owner, there's case law that says when that services is provided by the owner and not the municipality, then the same duty doesn't apply. Now that I'm speaking to you, I remember I had something like that once. When it doesn't apply, the same laws that applies, or the same requirement that applies to the municipality to give you sufficient notice before they're going to put off your water and your electricity, which is considered a basic right. It doesn't apply to private people. So if you're and sometimes and if your landlord provides you electricity and not the municipality, it is given through your landlord, because I believe some people get it from the landlord, and your landlord puts off your lights because you're in arrears. then there's no duty on him to timeously notify you. There's a reported case. I can't tell you the case, but there's a reported case on that. You can just look at that. But that was not your case, eh? We're just talking about an example.
Yes, indeed, Council. So urgent applications is just to give notice. It doesn't need to be sufficient notice, but a purely ex parte application such as admission, no notice should be given because there's no other party.
There's no party to be given notice to. If it's going to be for your admission as an attorney, the Legal Practice Council requires 6 weeks notice of before you put it down and set it down in court, because they can object to you being, but usually if they have any objections, that's why they want you to let them know 6 weeks before the time, so that they can tell you, look, you need to still meet this requirement and that requirement, or we're not happy. Fix your papers, but it's only for that purpose, and they're not the party, but that is a requirement. You're going to serve your papers on them also, and they're going to say no objections. They're going to issue a pro forma thing, we don't have any objections, and then you can set it down in court, and the court wants to see that they don't have any objections to you being an attorney. So that's that, but there's no requirements in if there's no other party to give sufficient notice to.
Okay, thank you very much for the guidance, Council.
Okay, Cindy Siwe.
Advocate, can you hear me?
Yes, I can.
Okay, perfect. I'm load shed. Pardon if there's any interruptions. In POCA applications with the NPA, even if it's the civil side with the asset forfeiture unit, ex parte applications are heard completely in camera, and then the second leg for confirmation of the order, that is the provisional order granted by the court, only then are the people so affected then allowed to then give cause as to why these assets should not be finally restrained.
Forfeited, yeah.
Yeah, it's first the restraint, then the confiscation, then the forfeiture, yeah.
Yeah. Okay, yes, because you see the nature of those proceedings. POCA is the Prevention of Organized Crime Act, for those of you who don't know what Cindy Siwe is talking about. Prevention of Organized Crime Act. So if a person has assets that they have obtained as a result of what do they call it, illegal activities, then that, and if you are arrested for a crime, or even before you're going to be arrested, you're a suspect, the government can lay claim to that. Now, obviously, that is not going to be in open court if they're going to bring the first application, because if they bring it in open court, then you're going to know, somebody can tell you, somebody can hear, and then you can go and hide those stuff. So it's brought in camera, and then they attach your stuff and take it, and then you can come to court on the second leg and tell the court why you, that was not illegally obtained with the fruits of the unlawful activities.
Yeah.
Not obtained with fruits of unlawful activities, that you've worked for it. You sold fruit and vegetables, that's usually, or you sold shoes, and that's usually the excuse. And that is how you made the money to buy your boats and your cars and all of that. And then the court will have to decide whether you should be given back your stuff. Otherwise, the state keeps it. And if the criminal case goes on and you are eventually convicted of the criminal case, then that's forfeited to the state. Then they just come back to court. But the two is in open court. But before they take it, that is in closed court. That is for that reason. And it is ex parte, yes. And there's a thing that I want to explain. You get an ex parte motion application, an ex parte, right, where there's one party. And then you get, and this is what you have been alluding to, you and Janus, you get an application that you bring ex parte, and that is a difference. An ex parte application, there's one party. If you bring an application ex parte, it doesn't mean there's one party. There is a respondent, but the respondent is not before court, so you bring it ex parte without the respondent being in court. But remember the first day what I said, important rule of natural justice in the High Court, the audi alteram partem principle. So when the court gives a decision in the absence of the respondent always get a chance to come back to court. So they would have a rule nisi, a return day, where the respondent can come to court and say why that order should not have been granted. But the initial one is brought ex parte, but it's not an ex parte application. There's a difference there. Okay.
So advocate, is that not the Anton Pyler application where you bring an ex parte application and there is a respondent, but in those circumstances, if that person became aware that there was something against them, then they would have done something shady. Therefore, on urgent basis, we should bring this application ex parte so that, you know, justice's wheels can turn.
Okay, so that an export, another example of an ex parte application, of an application that you bring ex parte. It's not an ex parte application. You bring it ex parte, but there is a respondent, would be an Anton Pyler application. But an Anton Pyler application is not a POCA application. POCA is in terms of the Prevention of Organized Crime Act. That is what POCA is. And Anton Pyler is if you have a civil action against somebody, and you know that if the sheriff rocks up at this defendant with this summons, this defendant is going to take that evidence that is essential for you to prove your case. He's going to take it and he's going to hide it, or he's going to destroy it. So if he does, if there's a real apprehension that you have that is going to happen, then you go to court and you do it in camera and you get an order. And that is one of the applications that we do, so I might as well do it now. It's a preservation order. Now, in that case, the court will then appoint another attorney who's not the attorney of the applicant, right? And remember, it is behind closed doors, so it's in camera. The court appoints an attorney, and that attorney is referred to as a supervising attorney. And together with the sheriff, they go to the place where the actual evidence is. Now, you must know what the evidence is that you think the defendant is going to hide. You can't just say he has evidence and make it a broad thing. You must know specifically what evidence it is that you want to preserve. The sheriff goes to the place where the evidence is being kept, and then whoever is in charge of that place, hello, we can hear you.
So sorry.
So the sheriff and the supervising attorney will go to where the evidence is being kept, and they will ask whoever is in charge, look, we are here. The same like they do with POCA. We are here and we want to preserve that evidence. You can call your attorney. They actually give a reasonable time when the attorney can be there, or the owner, the respondent, and they wait. And then once they come, or if they don't come and it's a long time that has elapsed and the sheriff is of the opinion that was sufficient time, they take the stuff into custody. They make a list of the stuff. Then the respondent can come to court and say, no, but this should not have happened because this is based on nonsense or whatever. I don't agree that I would have destroyed it or whatever. So, and it must be specific evidence for the Anton Pyler. So the POCA is criminal activities. But you bring the civil application. Yeah. So yeah, anything else? Let's go on. Right. Okay, so let's look at the long form of the notice of motion. It's exactly the same like you did with Advocate Pitt. You would, in the notice of motion, you would ask for the relief that you are seeking and the court in which it is being sought. The address must be within 25 kilometers of the registrar. 15 is incorrect. Registrar's office, that is 25 kilometers from the High Court, for the applicant to receive notices and service of document. Period within which the respondent must deliver his notice of intention to oppose, which is 10 days. If so, his answering affidavit. And then you would say, if you do not oppose it, then I will set it down for hearing in the unopposed court, and you can have a date there. I don't know if that is going to be the actual date, because the registrar will give you a date. different courts have different ways how you can get dates. In some, you choose your own dates. In some courts, they give you a provisional date and then a final date. Look at the practice directives of the different divisions if you are in different divisions. You would also in the notice of motion state the name of the person whose affidavits are annexed in support of the application. Okay, so you will say attached to this notice of motion is the affidavit of Mr. X. And so, yeah, is the affidavit in support of this application of Mr. X, yeah. And then it is signed by the applicant if he's in person or an attorney. Now, an advocate never signs a notice of motion. It is only an attorney that signs a notice of motion. You also don't have to have right of appearance in the High Court to sign the notice of motion. You can just sign it for the High Court. And it is addressed to the registrar of the division and the respondent, however many respondents there are. That is the notice of motion, the long form. Right. Now, the founding affidavit. In the founding affidavit, you will start by identifying the deponent. Remember, the deponent is not necessarily going to be the applicant. The deponent is the person that deposes to the affidavit. He can do it on behalf of the applicant, or he is the person who has personal knowledge because he's actually the witness here. He gives evidence. So if he's doing it on behalf of a juristic person, like a company or CC or some organization, he will say why that he has the authority, and he will also attach proof that he had that they've authorized him. A resolution was taken that he can depose to this affidavit, right? Then he makes an averment that the facts that is contained in the affidavit falls within his personal knowledge, and he will also state unless otherwise indicated, because some things he didn't know himself, he heard it from other people, if that is the case. Then he will identify the respondent. Now you follow also Rule 17, which is the rules for citation, the name or the name by which is known to the applicant, the occupation, and the address, yeah, and the gender. So, and then the jurisdiction of the court. If it is not apparent from the other averment, sometimes people don't put it in their papers that the court has jurisdiction. That's fine. If they don't put it in, if it's apparent from the papers. But for exam purposes, when you are going to draft, please put in that the court has jurisdiction by virtue of the fact, whatever the reason for jurisdiction is, because you're going to miss a mark. Even if it is apparent that the court has jurisdiction, they want to know that you know that the court must have jurisdiction to hear the matter. Then all the allegations that is needed to make out your cause of action, you will put the court in the picture. You will tell the court everything, all the facts that support the allegation, and then you will say, you will end it off, you will say, and I pray for the relief in accordance with the prayers contained in the notice of motion to which this affidavit is attached. You don't have to repeat the prayers again. And then you can, to an affidavit, you can, or you have to, if there's documentary evidence which supports the averments, you have to attach this documentary evidence. So you would attach it and you would number it. Now in practice, some litigants number it with the initials of the deponent. So if it was going to be me, Laureen Abrams, then it would be LA1, and the next one would be LA2, and or they would say founding affidavit 1, so it would be FA1, FA2, and for the other affidavits, answering affidavit AA1 or the deponent, the initials of the deponent. But you would number it so that we can clearly distinguish between the different annexures to the different affidavits. Right. Now I said that the deponent will say the facts falls within my personal knowledge unless otherwise indicated. Right? If somebody else told you something and you say it there, then it don't fall within your personal knowledge, and then it is hearsay evidence. Remember, this is evidence. Then it is hearsay evidence. Now we know that the court don't attach weight to hearsay evidence unless you can argue why it should attach that weight to it. But you can cure the hearsay value of that evidence by letting the person who told you make an affidavit, right? That is what we call the confirmatory affidavit. So if I say in the affidavit, I'm the deponent, and I say, and then Janus told me that he saw that this is what happened. I talk about Janus. That is not evidence that is personal to me, and I don't know it. So Janus must then make an affidavit. Now, a confirmatory affidavit basically just has the same heading, and it says, I, the undersigned Janus, what is surname, do hereby state under oath that this falls in with my personal knowledge, and then it just states, I have read the affidavit of Loreen Abrams, and I confirm it insofar as it relates to me. You don't have to repeat everything that I've already said in the founding affidavit that he told me. You don't have to do that. You can just say, I've read it, and whatever she talks about me, I confirm all of that. Then it's no longer hearsay evidence. Then he's also before the court. His evidence is also there. Right. Any questions at this stage? Yes, Richard.
Yeah, thanks, counsel. I just want to, on the issue of the confirmatory affidavit, and I deal with that on a daily basis. Once you give that affidavit and a person reads and he confirms that affidavit, now the person who needs, like Janus, who must do the confirmatory, says, but Ms. Abrams, I need to add the following to the confirmatory affidavit that was left out. Do you then take a supplementary affidavit or normal affidavit from Janus?
You didn't remember you did not yet file your papers, right? So you can either you can actually supplement it at that stage in the confirmatory affidavit. You can say, and I add the following, not to have too many affidavits, or you can have a separate affidavit, and you can say the affidavit of Loreen Abrams Janus, and then you can confirm everything, or they can amend the affidavit, and then it must be commissioned again of the main deponent. But you, at that stage, you can supplement, but you are only allowed 3 sets of affidavit, right? The confirmatory affidavit would be to confirm what is in the founding affidavit. Remember, the court must read the affidavit. So I would, at that stage, I would then amend rather, or I would, in the confirmatory affidavit, that they add whatever is added also in there.
Okay.
I won't put in the tramline's confirmatory affidavit. I would just say affidavit, and then he would confirm everything I said about him, and then he will add whatever he needs to add. That can't be wrong.
Okay. No, thanks. Thanks, Loreen.
Okay. Yes, there was another hand, Sikumpuzo, if I remember correctly. You put your hand down now. Your hand was up.
Yes, advocate. Can you hear me?
I can hear you.
Yes, advocate. There's a scenario here whereby the applicant says in his funding affidavits, Mr. So and so told me that he had acquired shares in a certain company, and that Mr. So and so is being alleged to going to join that company. So the applicant is saying that Mr. So and so told me that he acquired shares in that company, and that Mr. is going to join the X company. Can now the respondents who is alleged to have said that he had acquired shares deny that? And how can applicants then prove to the court that indeed Mr. So and so did say that he acquired shares in another company? I don't know if you're hearing me.
I hear you, but now wouldn't this be one of those instances where there is a dispute of fact that should have been foreseeable, where oral evidence would be needed because you need to prove something by by referring to oral evidence, isn't it?
Okay. So then.
So you would have used the action, or you would argue it in terms of the Plascon evidence, or you would have it refer to oral on that aspect, or to trial. Yeah.
Okay, which is the better option, advocates, if I can get your advice on that?
If you use the application, you use the application procedure already. And now there's a dispute of fact on the papers.
So now I need to deny it as a respondent that I didn't say that.
Well, there's a real dispute of fact. Does anything turn on it? Is that very important to what you are asking the court? Does a lot turn on it?
Yes, it is, advocate, because this individual who is a respondent in this case has been implicated that he assisted another company that is going to join, and he had acquired so and so shares.
At the time of drafting the application, did you foresee that he was going to deny it?
Who in this case? I'm for the respondents in this case.
Should they have foreseen that he was going to deny it?
I'm not getting you, advocate, but
should they have known that he's not going to agree, that the respondent is going to say no, but this is a lie? Should they have known that?
Yeah, I'm sure.
Then there's a dispute of fact that they have, so they've used the wrong procedure, so their claim can be dismissed, or they must apply to have oral evidence led. It's for them, not for the respondent. You just deny and you substantiate your denial, and then they must do it. Otherwise, they run the risk of the application being dismissed based on that. If one of the other, they don't succeed with one of the other. Because they should have foreseen that there was going to be a real dispute of fact, and then they should have used the action procedure. That is what you can argue also. And you can argue on what basis you say they should have foreseen that he was not going to agree. Because does it incriminate him if he should agree that?
Yes, it definitely will incriminate him if he should agree with that.
They should have foreseen that he was going to deny that, unless they're going to say that he's lying, and you must see what they say in the reply. But if they should have foreseen a dispute of fact, they should have used the action procedure.
Okay. Which authority will stand on advocates as a respondents on that allegation, on those allegations? Which authority would you suggest?
Now you want me to give you case law as well? Yeah. Off the top of my head. Yeah. I'm like I have to be a walking Google. I don't have it on the top of my head. The authority that they should have foreseen a real dispute of fact looked at Rumaier and Company, Rumaier versus Sheppey Street Mansions, where that explains to you when there's a dispute of fact. When a dispute of fact arises. Rumaier. It's in your notes also. And then look at cases. Okay, let me just give you this short lesson. It's just for you. The others that knows this already. Sorry about that. Then you look at where they have applied room hire in recent cases and how they applied it and what was decided in that. And then you use the most recent cases also. Okay, so look at room hire and where room hire was used. You usually would see in the latest cases, you put room hire in, and in new cases where that was used comes up. And then you use the newer cases. Okay.
Okay. Room hire for me is RAUM.
No, room, kamer, room hire. Versus as in your guide.
In your guide, okay. Thanks, advocate.
Just read your guide. Yeah.
Okay,
we passed 7. We passed 7. I think people want to go on the comfort break. There was a hand up.
Sorry,
was that for the comfort break? Oh, yes.
Sorry. Before we go, can you just quickly, sorry if this is repetitive, but just quickly before we leave, for break, just explain to me again the difference between a supporting affidavit and a confirmatory affidavit.
I didn't say there was a difference.
Okay.
What do you mean by supporting the founding affidavit?
No, I thought, I don't know why.
The question was relating to a supplementary affidavit, supplementing an affidavit or putting more information that was left out in a previous affidavit. That is what a supplementary affidavit. It contains more information to inform the founding affidavit. That is
Okay,
what
sorry.
was
No,
meant by that.
advocate.
Yes. Yeah.
No, so there is no difference in any ways between a supporting and a confirmatory affidavit in any
No,
event.
no, you can call it a but confirmatory means he confirms what was said in the main affidavit about him. Yeah.
Okay, perfect. Thank you, advocate.
No problem. Okay, it is now 5 past. Let's get together at 20 past. Let's take a comfort break.
As the court pleases.
Yeah.
Silence in the court, mute. Yeah.
Ao a se re mamola go na le batho ba ba rekang go tshwana le wena a se ba reke fela dilo tsela motho wa reka ba modiri wa reka ya batho ba bangwe ba a ba e shopping mamola a se taba tsa rena gore ba tlisetsa rona fela nna batho ba bangwe a ba e shopping ka mokgwa kutlwano a rekang diaparo le dijo o kgone di reka ka mokgwa no le wena ka bosigo ga o nye go shopa o ka no shopa ba o tlisetsa sorry
I'm back. Let us proceed. Yeah. The answering affidavit, the same as with the plea, all the allegations in the founding affidavit must be addressed. Admitted, denied, confessed, and avoided. Denials must be substantiated, and if you have a defense, set out your defense and the facts that support it. Again, you can attach documentary evidence. You have to if there is documentary evidence. You can't in court hand up evidence. Okay. In the replying affidavit by the applicant cannot bolster evidence in the founding affidavit. You are limited to a response where it's necessary to factual allegations by the respondent in the answering affidavit. Now, these are the only 3 sets of affidavits that you can file. Remember the founding affidavit and whatever is necessary to cure hearsay evidence, or hearsay evidence and evidence by other people, that must all be found first, and then the answer to that, and then the replying affidavit. You are not allowed to supplement your affidavits without the leave of the court. What that means that if you have forgotten to put anything in an affidavit that is very essential to your claim, you have to bring an application. So it's again a notice of motion and an affidavit wherein you explain why you should be afforded the opportunity to file a further affidavit. You can't just file a further affidavit on your opponent and on the court and think that it will go in. You must have the leave of the court. They're very strict with this. So no further affidavit is allowed. You stand and fall by what is in your papers. Okay, unless you bring an application to file another affidavit, and then the court must consider whether you should be allowed to file another affidavit. Right. I've already talked to you about ex parte applications where there's no other party. Then we've also talked a bit when we did actions about interlocutory applications. Maybe I didn't mention, call it interlocutory applications, but that would be when an exception is raised and you go to court, where you do an application for an amendment where the defendant objected to an amendment. Applications to compel. Those are all applications that are ancillary to a main action or application that is already in court. And these applications, the first process must not be served by the sheriff because there's already an action going on in court and it all relates to that action. So it will be under the same case number, but it's ancillary to the main action. It runs parallel to it in another court. In some divisions, they have dedicated courts where interlocutory applications are being heard. Application to compel, to file discovery affidavit, or to file an heads of argument. Those kind of aspects are dealt with, and that is interlocutory applications. Right. Now I'm going to deal with specific applications, and the first one that I'm going to deal with is urgent applications. Now, urgent applications are dealt with in terms of Rule 612. And the first prayer that you're going to ask, okay, if you're going to bring an urgent application, now let me just go one step back. The court, the High Court, is available 365 days a year, 366 in leap years, 24 hours a day. There is always a judge on duty. You always have access to the court, right? How it works is that the judges goes on a roster. Say there's 40 judges in a division. They're on a roster and you get your turn when you are on the urgent court roll, right? Those that they usually have 3 judges, or some divisions is so big, they have 4 judges that does the urgent roll and the motion court. That is the unopposed motion court. So between them for a week at a time, they would do that. So if you're a judge in a specific division, maybe twice or sometimes thrice a year, you will do that urgent court where you are available from the Friday 4 o'clock until the next Friday 4 o'clock, whenever you are needed, right? So usually when you bring an urgent application, your first port of call would be to find out who is the urgent judge on duty for that week. That is easy to find out. You would phone the registrar. There's also a registrar that is an urgent. The securities at the High Court would usually be able to tell you who's the registrar on duty. So if you are going to bring an urgent application outside of the normal court day, when people are not at the court, the staff is not there, the judges are not there, you must then inform the registrar that you intend to bring an urgent application, right? Then the registrar would ask you, okay, you won't get a chance at this stage to speak to the judge. The registrar who is on urgent duty will ask you, okay, why is the matter urgent? Because that is what the judge will want to know. And it must be urgent for the judge to hear a matter outside of the normal court hours, let alone outside of the normal turn that you have in the queue, jumping the queue. So for a judge to come to court 2 o'clock in the middle of the night, the matter must be very urgent. They usually say, where's the burning house? Who's going to die if the order is not given now? Can it wait till tomorrow maybe? Can it wait another day? And if it can, then it has to wait. But if it is so urgent that it must be heard at that stage, then the judge will come out. So the registrar will ask you, why is it urgent? And you will have to tell the judge, if this matter, if I don't get the order now, then this and that will happen. And usually if it's life or liberty that is at stake, that is very urgent. If somebody's going to die, if a house is burning, it must be put down. That is very urgent. If it is a commercial interest, you're going to lose money or whatever, that is not so important. You can always claim money back. So there's different degrees of urgencies. And depending on the degrees of urgency, you will be allowed to break the rules. Remember, you are not sticking to the normal court times. You are bringing it outside of the court time. Even on a weekend, even if it's after 4 on a normal day, that is outside of the normal court time, right? Sometimes it must be necessary. It may be necessary for you to get relief like that, right? Now, you would ask the court to depart from the usual forms of service. We know that in terms of Rule 4, the sheriff must go serve the first process. You ask the court, okay, that's not going to happen here because we can't still wait for the sheriff to open and to go and serve it and all of that. You're not going to comply with the times where the respondent get 10 days in which to give a notice of intention to oppose and then another 15 days to file his answering papers. No, that is too long. We can't wait for that. We want to shorten the time. In fact, there's no time even for the respondent sometimes because life and liberty is at stake. We also can ask for the departure from the obligation to serve the notice on the respondent. So no notice is served on the respondent before you go to court. That is when you bring it ex parte, but there is a respondent. And the departure from the prescribed form for the notice of motion. Sometimes you're going to bring it so quick you don't even have the correct form of notice of motion. Now the practice directives tells you that you must as far as possible stick to the long form of notice of motion, and you must in each and every case where you are going to bring an urgent application inform the respondent that you are going to court. Remember, usually when you go to court on an urgent basis, you would have had communicated with the respondent. And just because you couldn't agree, that is why you're running to urgent court. And you would have said, look here, if you don't do X, Y, and Z, I'm going to court on an urgent basis. So you must inform the respondent by any which way that, look, I'm going to court at 10 o'clock this tonight. My attorney is busy preparing the papers. We're going to court at 10 o'clock tonight and we're going to bring an urgent application. Then the respondent knows, and you must tell the court that the respondent has been informed. They want the respondent to know, even if the respondent is not before court. And when I say not before court, I don't mean not physically there. It includes that, but the respondent can even be at court, or the respondent can even have a legal representative at court. But he's not before court because there's no papers of the respondent before court because it was so urgent. He didn't have time to respond to whatever you are asking for. He's maybe got the papers or maybe he doesn't have it, but he's there physically, but he's not before the court. There's no evidence of the respondent for the court to consider, right? You would, there's different degrees of urgency, and it must commensurate with the different degrees of relaxation of the rules. Sometimes it's not so urgent, but it is still urgent that you can't wait for due course, for your date in due course to come up. So the matter is urgent, you want to go, you know today the matter is urgent, you want to go to court next week. That's still jumping the queue by far, because people must wait a whole term for the new date. You're going to jump the queue, but then you let the respondent know, and the respondent can have time to file papers, but you shorten the time. You can say, you're within 2 days, you must let me know if you're going to oppose, and the following day, please file your answering papers. So that when you go to court next week, then there's a full set of papers. You can determine the times, you as the applicant. Obviously, the respondent, and the respondents do this, they would come and they would argue to the court that the time limits and the times was not necessary, the matter is not urgent. And then they can have your matter struck from the urgent roll, and then your matter must go on to the normal roll. Not dismissed, but they just can attack an urgent application based on the fact that it is not urgent. Also, if you know something is going to happen and you sit and you wait, you know for months and months, your husband is going to take the child out of the country. Now, the day before they are about to board the plane, or the night when they are at the airport, now you want to run to court. Okay, that would be very urgent. That's a stupid example because liberty and all of that is at stake. But if you have created your own urgency, the court won't be sympathetic with you if you've waited till the last minute. The minute you know something is going to happen, you must act on it. You can still bring an urgent application to stop that. But don't create your own urgency and wait till the last minute. You know you're going to be retrenched on a specific date. You've been given the notice. Now you wait till the day that you retrench and you run to court to stop it. That is a better example. Okay, so don't create your own urgency. I don't know if there's hands up. Let me just see. No, there isn't. Right, so the degrees of urgency, and this case, where they describe the degrees of urgency and the degrees of the relaxation, is the Luna Meubileerders versus Marken. It's a famous case. And then, yeah, you can just look. I think they do quote it in your notes. So you would, if you bring an urgent application, now I'm not talking about I'm just talking urgent in general, where you're not going to meet the normal times. I know in Gauteng, if you're going to bring an urgent application, then your papers must be filed on before 12 o'clock on a Thursday. I'm speaking under correction. Before 12 o'clock on a Thursday, and then the matter will be heard on the Tuesday. That is normal urgent matters. Okay, yeah. You ask in your prayers for an order that the court condone your non-compliance with the rules. And then you also ask that the matter be regarded as an urgent matter. Right. And then obviously what the relief is that you want on this urgent basis. In your affidavit that supports this notice of motion, there must be a paragraph where you describe why the matter should be regarded as urgent. Okay, and the court must agree that the matter is urgent, and your opponent can, like I say, just oppose the urgent application at the first stage on the urgency aspect and say the matter is not urgent and should not be heard, and they can strike it from the roll just for that reason. Now, usually an urgent application, if you bring it, it will be for an interdict. The common scenario is you oblige somebody to take action by means of a mandatory interdict, which is called the mandamus. Or you can oblige someone to refrain from doing something, which is a prohibitory interdict, right? And usually the matter is so urgent that you can't wait for the legal vehicle to obtain redress in due course. You must get the relief now. So an urgent application would lead to you can either bring it on an interim basis for interim relief, where the opponent is not in court, right? Or for final relief, where you ask for a final interdict, right? And from your studies at university, you would remember the requirements for an interdict. If it's for interim relief, there must be a prima facie right, a well-grounded apprehension of irreparable harm if the interim relief is not granted and the ultimate relief is granted. That the balance of convenience favors the granting of the relief and that there's no other remedy. If you're asking for final relief, for a final interdict, then there must be a clear right, an injury that is actually committed or reasonably apprehended, and that there's no alternative remedy. So you would have your, if you draft your application, you would have your heading, then you would have the affidavit, then you would say why the matter is urgent, and then you would write your cause of action, meeting each and every requirement that you have to. Now, if you are getting and if you're bringing the application without the respondent being present in court, then usually the court will have a return date. On the return day, the respondent can then come to court and say why the relief should not be made final. Now, the respondent don't have to wait for the date of the return day. The rule says that the respondent can anticipate an earlier court day within 24 hours after he has received the order, the interim order. He can be back at court and tell the court why the order should not have been granted and should be dismissed. Right, this is on page, I think page 105 or something, not 105. Let me see what page it is. There's an exercise. One of the exercises that you must do, it relates to Farmer Brown. Let me just see. Just bear with me. Page 207. Page 207. Or what is it? A. I've just got the answer here, basically as to how you would do that. It's an urgent application that usually if you were on one-on-one, I would have asked you to draft it. So this is basically just how you would do that notice of motion. And then the founding affidavit, I don't have the whole one here, but I've got the headings. So you also have it. So look at that. Just know that it is on page 207A, that question, by the self-assessment questions. Okay. Are there any questions on urgent applications before I move on? Any questions on urgent applications?
Advocate, how are you?
I'm fine, thank you. Yourself?
I'm fine. Speaking to Sambo here. Advocate, I wanted to find out something, right? I've been in court the past few days, and before matters can be heard, you find that there's other people that have their matters on the roll, and most of those matters have been agent matters. And my question is basically, who gets to determine the agency of the matter? Is it the merits of the matter or the discretion of the judge? Because I do understand that they have to actually put it to the test to check whether if this matter, does it cause harm for it to be given as an agent matter. So I wanted to find out who does a discretion lie on to determine whether the matter is agent, because my merits could actually say that the merits on paper could say that this matter is super agent, but then the judge or the magistrate therefore decides to say that no, the matter is not agent. I wanted to find out that. Thanks.
It depends on the judge. Obviously, was it in the High Court that you were doing this matter, sir?
Yes, it's in the High Court.
And which High Court, if I may just ask?
In Pretoria, the High Court in Pretoria.
The judge has the discretion. Was the respondent in court?
Yes.
Did the respondent address the court that the matter is not urgent?
No, in fact, the respondent didn't address the court that the matter is agent, whereas us were saying that the matter is agent, but the judge,
no, not urgent.
Yeah, so it seems, sorry?
No, did the respondent argue that the matter is not urgent?
No, they didn't argue that the matter is agent. They
not
only,
urgent.
Yeah, they
not
only submitted
urgent.
that. Yes. So they only submitted that, look, the matter has to go on because we were trying to prohibit the matter from being heard on a particular day in the future. But then the respondents just said that, look, no, the matter should continue to go on the given date. We understand that it could be an agent matter, but it seems that the judge didn't even address the part from the respondent, only attended to our case, and in his judgment, he never even touched on the merits of the facts by the respondent. So it's kind of confusing sometimes because of, like,
yes,
as I was saying,
the discretion to determine whether the matter is in fact an urgent application. So the judge has the discretion. So he can say the matter is not urgent and it should go on the normal roll. Did he say that?
Yes, he said that.
Yeah, it's the discretion lies with the judge to say. But usually the respondent can also address him if the respondent doesn't agree. But if he, based on what your papers don't agree with you, then he can dismiss, strike it from the urgent. Yeah, he can. It's the judge.
No, okay, I understand. So a second question, because I've got two other questions. The second question is, can we appeal the judgment of agency that is given against us?
Is that okay? What kind of judgments can you appeal? Only final judgments. So he did not make a final decision on the merits of the matter. It was only on the fact that it's not urgent. He didn't say the claim is dismissed. He said go on the normal roll. So you can't appeal it. Yes, you can only appeal final judgments.
Okay. The last quick one. I think maybe I might have skipped the bus as you were explaining this. I wanted to find out the importance of having a filing note or filing notice. Is it important? Because I've realized that when I go and issue summons, I go to submit summons in the High Court to the registrar, I have to have a filing note or notice that just describes what's in the, it's more or less like an index to everything. Is it important to have a filing note when it comes to the exchange of court papers between parties?
The rules doesn't say that there must be a filing note, but the convention is that whenever you're going to file something, that you do have a cover on it with a file, which is the filing note. Yes, that is the convention.
Okay. No.
Okay. Right.
Thank you, sir.
Okay, no problem, Mr. Director. Director Sambo. Or Sambo Director. Yes, the next other person whose hand was up is Lepelo or some. Sorry if I'm not saying your name correctly. Do you still have a question? No. Okay. Let's move on. Another specific application is the application in terms of Rule 58, which is an interpleader application. Now, an interpleader application, you've done this with Mr. Pitte, with Advocate Pitt. Did you? Did you do interpleaders with Advocate Pitt? Anyone?
Yes, Counsel. We did do a couple of interpleaders, but not in the. I cannot remember if we did it in the application, but we did interpleader in the case of like exception and application to strike out and things as such.
Interpleader. Okay. Let me just tell you when you would use an interpleader. Now, the reason why I'm asking if you did it with Mr. Pitt is it is an application, so yeah. If, for example, I'm going to give an example to explain this in the magistrate's court, starting there. You are judgment has been granted against the person, right? And this person doesn't satisfy the judgment debt. The court ordered he must pay an X amount and he didn't. Now the judgment creditor was the plaintiff, has a writ of execution issued. He gives the writ of execution to the sheriff of the High Court. Oh, sorry, we're talking about the magistrate. To the sheriff to go and execute this judgment. The sheriff then takes that writ, goes to the place where the judgment debtor is, and says, I've got this writ, can you satisfy it? The judgment debtor says, no, I don't have the money. The sheriff starts and he attaches the property, the movable property. So he writes up everything that is there in the house or at the place where the judgment debtor is, right? In the car, in the garage, there's a vehicle. He writes that up. He writes everything up and he takes the stuff. He's going to sell it now at a public auction. And the proceeds of that public auction will then go to the judgment creditor, Woolworths. Okay, so Woolworths got a judgment. You bought stuff on their accounts, or and you didn't pay it. They got a judgment against you. The sheriff comes, he writes up the stuff, and he takes everything because they're going to sell it to satisfy the debt, because that now belongs to Woolworths, right? You tell the sheriff, look, that car is not my car. It's my friend's car that I'm just driving for this week. The sheriff don't listen to you. The sheriff takes the car, right? Because it now belongs to Woolworths. The sheriff is there on behalf of Woolworths. Your friend wants his car back. Woolworths says, no, the car must be sold so that I can get my money in terms of the judgment. What does the sheriff do? Must he now play lawyer and decide, play court and decide whose car is it? Is it the friend's? Is it Woolworths? No. The sheriff then serves an interpleader. And then the court must decide who is the person who is entitled to that vehicle. So the friend must then bring the papers and he's the owner, and it's not the judgment debtors. So therefore Woolworths doesn't have a claim on it. Do you understand? That is how interpleader work normally in the magistrate's court. Now in the High Court, it works on the same basis. And the example that they have, I think in your notes, if they still have that example there, is a farmer, and I'm speaking loosely here on the facts, a farmer wanted to sell his farm. An estate agent came to him and he said to this estate agent, look, I want to sell my farm. Get me a buyer. Weeks pass, the estate agent comes to him with a buyer who buys the farm, right? Now, the farmer receives communications from two estate agencies. The first estate agency is the estate agency where the person was employed when he initially went to the farmer. Unbeknownst to the farmer, when he came there with a buyer, he had changed jobs and he was working for another estate agent. Both of those estate agencies are claiming the commission. The farmer knows it belongs to one of them, but he can't work out which is the rightful one. So he knows it belongs to one of them, but how does he deal with that? Because if he gives the money to the incorrect person, somebody may take him to court and a judgment may be handed down against him. So he serves an interpleader. And then the court will decide who is the person that is the rightful, that has the right to it, right? So that is what they mean when they say a person under liability in respect of which he or she is or expects to be sued by two or more parties making adverse claim may deliver an interpleader notice with affidavit to the claimants, the two people who are claiming it, the sheriff and Woolworths, or the two estate agencies, right? The interpleader notice must state the nature of the liability or the claim, which is the subject matter of the dispute. Call upon the claimants to deliver particulars within time period indicated, not less than 15 days from the date of service, and state that on a further stated date, not less than 15 days from the previous date, the applicant will apply to court for its decision as to his or her liability or validity of the respective claims. The affidavit by the applicant must set out the facts, and he must state in his affidavit that he doesn't claim any interest in the subject matter in dispute other than for charges and costs. He must also state in his affidavit he's not colluding with any one of the claimants. He is willing to deal with the subject matter in dispute as the court directs. On delivery of the notice, he must, if the claim relates to money, pay the money over to the registrar. If the claim relates to a thing which can be delivered, tender it to the registrar. If the claim relates to immovable property, he places the title deeds in possession of the registrar, and he provides an undertaking to sign all documents necessary to effect transfer in accordance with any order that the court may make. That is when he would use an interpleader. If a person expects to be sued by more than one person and he doesn't know who's the rightful person, he serves an interpleader notice. He's not taking sides. He will deal with it as the court say. He even keeps the money. He knows he owes one of them. But yeah. Any questions on interpleaders? I don't think that is what you meant when you say interpleader with exceptions and that, because this is something totally different. Any questions? None. Right, we did this application, the appointment of a curator ad litem. You can just look again at this pictures and all of that. Anton Piller, I've just explained because somebody asked something about it, so we've already done that. That is all got to Anton Piller. This question here is just to test, it was in one of the papers, to test your ability to draft an index, because you would know that your attorneys will have to paginate, collate, and index the file. This would have tested that it's a person whose husband is going to, you're bringing an application for a curator ad litem, and then you need to know what documents must be in the file. So you have to paginate the court file at the second hearing where you have the curator bonis appointed. So all of that must be in there. Right. PI applications is another application. This is just, your notes have all this, I suppose. Let's look at PI applications. I don't have anything on PI applications, but let's talk to PI applications. This was, I think this is a guideline as to how to do a PI application. Right, a PI application is prevention of illegal eviction. Prevention, like what is the wording? Illegal eviction of an unlawful occupation of land act. But let me just see. In any event, let me talk about PI application. So if you're going to, in terms of the PI Act 19 of 1998, that's as much as I know, Prevention of Illegal Evictions and Unlawful Occupation from Land Act, right? We call it short the PI Act. If you want to evict a person from their residence, from their primary residence, then you must use the procedures as laid down in the Prevention of Illegal Eviction of the PI Act, right? So you would start by having a section 4.1 notice served on the respondents, right? It's an application procedure. So you would have the section 4.1 notice of motion and the founding affidavit served on the respondents, right? Then you would obtain a court date. And then once you have the court date, this is the procedure in the magistrate's court really. Then once you have obtained the court date, then you bring an application in the, they do it in the open motion court. It's an ex parte application to serve the section 4.2 notice on the respondents. Now, the court will tell you whether it must be served personally on each and every of the respondents, which usually is what the way they go. And the notice in the section 4.2 notice, so they already have the section 4.1 notice. It's an application, so they have the opportunity to file a notice of intention to oppose and the opposing affidavit. But even if they didn't do that, you must still do the section 4.2 notice. If they did it or if they didn't do it, you must still do the 4.2 notice once you have the court date, because the section 4.2 notice must be sent not less than 14 days before the trial date, before the hearing date that you have obtained. And in the section 4.2 notice, you give them another opportunity and you inform them of their right, that they have the right to housing or have right to go legal representation, and they can go to legal aid and be and when the court will hear it. So you inform them again, even if they did not oppose the application, right? Then at the hearing, the court will then decide whether they should be evicted. Now the court, you must make out in your papers, you must make out a case that they have alternative, they can afford alternative accommodation. If it is a household headed by older people or disabled people, or they are so those kind of people living in the house, special consideration must be given to them. Yeah, it is not incumbent on the respondent to provide housing for the alternative housing to the tenants, to the respondents. There's a recent constitutional court case. It's Phillips versus Grobler. It's not in your note. It was last year. Phillips versus Grobler, where there was an 82-year-old woman or 84-year-old who was evicted. And the court said in that case that there's no obligation on a private owner of property to provide alternative housing. Remember, in a PI application, you must also join the municipality, and they usually would provide a report to court to say that they don't have alternative housing, or they do have whatever. They usually don't have. But the court said in the Grobler versus Phillips case that the respondent is not required to provide alternative housing, although in that case, the respondent arranged alternative housing for Mrs. Grobler and her son. She was in her 80s and her son was living with her. He was also an elderly person. He arranged out of his own, but the court said even though he arranged for them alternative accommodation, it is not a requirement. The PI Act is lengthy. Sometimes it is seen to be unfair towards landowners or homeowners, because people live in your property and you can't just evict them. They sometimes ask for extension in court, or they give special circumstances as to why they couldn't move out immediately. Sometimes the court indulges them and give them more time, especially if they're school-going children and the school year needs to be finished. But at the end of the day, it is only delaying tactics, and they will have to move out eventually. The court weighs up the right to housing and the right to ownership of property and try to balance the scales with that. But I must say that the court always acts more in favor of the tenants, of the illegal occupants. Yes, Karabo? Karabo Mabilo.
Yes,
Yes,
can you hear me? Sorry about
yes.
that. Advocate, just a quick one. I'm not sure if it would be relevant, but just a quick scenario, right? A couple was married, got divorced, right? And there was no issues. And the court, the judgment upon divorce was that they must liquidate all assets, correct? And then part of the asset was a property. Then the court appointed a liquidator. The liquidator obviously liquidated all assets and sold the property, right? Now, when he sold the property, he got a guy who purchased the property, signed the OTP and so forth. And then he promised the guy that, you know, don't worry, upon registration of the property, you will be able to move in. But upon registration, the wife, the ex-wife, did not move out of the house because she said she does not agree to the sale of the property. I'm not sure, I'm just trying to find out who then applies for eviction order. Does anybody here actually have is anybody even allowed to apply for an eviction order in that scenario, whether it's a purchaser? Because I don't think the ex-husband, you know, has capacity to do that, because I'm assuming that they said the assets must be liquidated. So none of them can own anything anymore.
Just when you buy a house and there are tenants in, the person who buys the house becomes the owner and becomes in charge of the property and has the locus standi to bring the PI application. So it would be the new owner who evicts her. If she has a resistance if she's got a complaint against the liquidator for selling the house, is it because of the price, or is it because of the actual order to liquidate the property? What is the fight?
It's the actual order. She says she did not agree to that order. That's what she's saying.
Yeah, but the court appointed the liquidator. So you don't have to agree with the court order if the court orders it, if it's not by agreement between the parties, but by order of the court. So she's bound to that. So yes, the new owner has locus standi to bring the PI application.
Perfect.
Because
Thank
that
you so
happens
much.
a lot when properties are sold in auctions. The bank gets an order to execute the immovable property, but the people still live in the property. They fell behind on their bond. They remain there. The new owner must bring a PI application to get to evict those people from the property. Yeah. Any other questions? Yes, Karabu. Karabu's your hand up from earlier.
Yeah, no, sorry, I lost you there. My hand is from earlier. I'm going to put it down. Thank you, Advocate.
Okay. Right. That was short. Yes.
Advocate.
Yes. Continue.
Yes. There is a scenario, like a case that is going on where I'm at. It's an eviction case matter as well, whereby the unlawful occupier has never responded to anything, to the notice of motion, notice to defend, and there is a set court date in early next month. And should the unlawful owner doesn't appear in courts, would the courts grant the order?
If the court is satisfied that he had notice, there was the section 4.2 notice served on him.
Everything was served on him, but he never replied anything. No notice to defend. Just
personal
quiet.
service. Was it personal service on him of the section 4.2 notice?
I can't answer you, but it was sent by the sheriff because he got a return of service for everything.
Personally served on him. You say you didn't reply, but was it personally given to him?
Yes. There's
the court can give the eviction order in his absence. If the court is satisfied that he knows about the matter, then the alternate principle has been applied. He can't hold the court hostage by not participating and thinking that because he's not there, the court won't make an order. If the court is satisfied that he knew about it and everything is in place, the process was followed, then the court will make the order.
So should he not appear on the court dates, then it's been
if he's not there and he knows he must be there and he knows about the date, then the court can make the order in his absence.
Okay, hopefully.
Can I just jump in on a practicality perspective? And we've seen quite a lot of this in your mining towns. This happens quite often. I think someone who's close to me has actually been a victim of one of these scams, and I call it a scam because that's what it is. And I'm not saying that the law is a scam. Obviously, a court would apply the rules and would follow a certain procedure and would come to a decision. But this happens so often where someone who's a rightful owner of a particular property and they bought it at a time when housing prices were low, and they went on and paid the bond and all of that, and then they thought they were rightful owners of the house, and then at the time where they get retrenched by the particular company, and I'm talking about Sasol 1 and Sasol 2 in Secunda and Sasolberg, this happens so oftenly that they get all these orders where they are told that they are unlawful occupiers, and because at that point they are retrenched, they have no access to lawyers, they just ignore those orders, and one day red berets with a couple of or red ends, sorry, with a couple of police officials with a warrant tell them that they have less than an hour to get out, and things get destroyed, and people really do not understand what they are going through. But at that point, the law is waving its mighty hand, but people that do not have access to thorough legal advice because of financial circumstances and unscrupulous lawyers are actually involved in this. So this is something that happens, Composer. It's not something that is fictitious or theoretical. This is something that really happens, and people lose their homes because of unscrupulous lawyers, and the fact that there is law. And someone with a warrant that goes to the police have no other order other than to follow the warrant that has been given to them. Whether that person responds to the notices or they do not, it really does not matter. This is something that is reality, and this is probably one of the reasons some of us are lawyers today.
Okay, thank you for that. Any more comments or questions?
We will debate that soon in court with my learned friend.
About the unscrupulousness and all of that. Yeah. Okay. Next we're doing review applications. Now, Rule 53 of the Uniform Rules deals with review applications. Now, Section 21 of the Superior Courts Act tells you the grounds for which you can bring a review application. Now, a review application is usually a review of a lower court. The High Court reviews decisions, not of its own other judges, but of lower courts and quasi-judicial bodies. Like, for example, universities, organizations, sports committee, sports bodies who makes decisions. If you're not happy with that decision, you can take it on review to the High Court. The grounds for review is usually that can be absence of jurisdictions on the part of the court, that the presiding officer or the magistrate had interest in the cause, were biased, malice, or corruption on the part of the presiding judicial officer, a gross irregularity in the proceedings, where an incorrect, the court admitted evidence that should not have been admitted, or did not allow the admission of evidence that should have been allowed, right? That is the admission of inadmissible or incompetent evidence, or the rejection of admissible and competent evidence. Irregularity refers to the method of conducting the trial, and to be gross, it must be of such a serious nature that the case was not fully and fairly determined. That is the grounds for review. Now, the review application, it's an application, but it differs from the normal Rule 6 application in one aspect. When you implement the review application, it is addressed in the notice of motion to the decision maker also. So you have the respondent and you have the decision maker. The decision maker would be the chairperson of the arbitration, the chairperson of the not disciplinary hearing because it's the High Court, but the chairperson of the sports body or the university, or the magistrate. It is addressed to him, and he is called upon to provide the record of the proceedings and the reasons for his decision. And in the affidavit attached to the notice of motion, the applicant will set out the grounds for the application, why he says that the application should be reviewed. Once the presiding officer furnished the record to the registrar of the court, the registrar will let the applicant know that the record is ready. The applicant will then make copies of the record and send it to the respondents. The applicant will then also, after he has looked at the record, decide whether he's going to amend or vary or abandon some of his grounds or add new grounds. He can do that because now he has the record of the proceedings. So once he has done that, only now must the respondent file an answering affidavit. So, and it usually, there's no time prescribed as to when the presiding officer should make the copy of the record available. It should be made available within a reasonable time. Sometimes it takes months and months. Sometimes it's quick. Sometimes it takes months and months for the record to be made available. But it's only once the record has been made available and the applicant has filed a notice to say, look, I'm going to amend my grounds, or I'm going to add, or I'm going to leave it as is. They must just let the respondent know, and then only the respondent needs to answer those proceedings. The replying affidavit is then filed, and then it is set down as a normal opposed application and argued. So the only difference is the first notice of motion is addressed also to the decision maker to provide the record, and then the applicant gets another chance to change the grounds for his review, and then only the respondent replies. Right. This is just a comparison between the normal application and the Rule 53 procedure. You can read through that on your own. The differences between the appeals and reviews is in your guideline. You know that the review is got to do with the method and the method that was applied, and also everything that is outside of the record, not necessarily only reflected in the record. Whereas an appeal got to do with the record, where you are bound by the corners of the record when you appeal. Right? That is one of the huge differences between an appeal and a review. Apart from the fact that the review don't have a time when you must bring it, a review application must be brought within a reasonable time, whereas an appeal, you must apply for leave to appeal 15 days after the judgment has been handed down. If you're going to bring it in writing, you have 15 core days to bring it, right? On appeal, it is contended that the presiding officer came to a wrong conclusion on the law. In the case of the review, you say that there are many, that he didn't apply his mind, he didn't allow evidence, he was biased, all of those grounds that we looked at before. So that is the basic differences between the two procedures. Now the appeal procedure, usually if you're going to appeal a judgment, you're going to bring an application for leave to appeal, and it is before the same judge who handed down the judgment. You can do it orally immediately after he has handed down judgment. So he gives the judgment, you can get up and you can say, my lord, I have instructions to bring an application for leave to appeal. The grounds for the application is the following. You were wrong there, you were wrong there, and you were wrong there. So basically that is what you do. The application in writing, obviously, then you're going to write it down. 15 days you have, and then the judge's secretary will let you know when they will hear the application. So you don't do it to the registrar of the court, but to the registrar of the judge. You send the notice to application for leave to appeal. So you don't just appeal directly, you first ask permission. And the test that the courts apply when they hear an application for leave to appeal is, will another court, when it hears this case, this facts, and applies the law, will it come to a different decision? Is there a possibility that another court may come to a different decision? And if the answer is yes, then the court will give you leave to appeal. If the answer is no, if the court says no, another court looking at this will come to exactly the same decision that I have come to, then you don't get leave to appeal. Now, if the court to which you apply, the one that handed down the judgment, refuses leave to appeal, then you can petition the Supreme Court of Appeal. Now, when you petition the Supreme Court of Appeal to appeal, it is they say petition because historically you had to write out a petition. It is a strange document. They don't do it that way now. They still call it, you petition the Supreme Court of Appeal, but it is a notice of motion and an affidavit. So in the affidavit, you would set down out the reasons, the grounds for your appeal. You would tell the court that you've applied for leave to appeal in the High Court and it was denied. The application must be accompanied by a copy of the judgment of the court, ACWO. ACWO means the court below whose decision you want appeal, and the judgment also refusing the leave to appeal if that is the case. And your opponent can file an answering affidavit if he has an answering affidavit, and then the appeal judges may grant or refuse leave to appeal. Now, how this is heard is people for leave to appeal to the Supreme, which is in Bloemfontein, people don't go there physically and argue the application for leave to appeal. The judges decides this in chambers. So you send your notice of motion and your affidavit with the necessary other documentation attached. They look at it and then they will decide whether they give you leave to appeal or not. If they give you leave to appeal, then you must file your notice to appeal, setting out your grounds, and then follow the rules further. 20 days after leave is granted, you must file your notice. And then so you must state in the notice of appeal which part you are appealing against, which part of the record. Specify the findings of fact and or the rulings of the law that you are appealing against, and specify the grounds upon which your appeal is founded. Right. That is that. Any questions on that?
Advocate,
yes, you may speak.
If for whatever reason you miss the 15 days, the first instance when you want to apply for a possible appeal, or you request rather the judge that made the order to basically to appeal, can you apply or request condonation?
Yes, you can. But when you're going to apply for condonation, you must address the following in your affidavit. So you bring an application, so it's a notice of motion. Where the relief is, you apply for condonation for the late filing of your application for leave to appeal. Right? Then you must tell the court how long the delay is, what is the reason of the delay, why you are late, and most importantly, that you have a good chance of success should you be allowed to get leave to appeal. So you go into the merits of the matter.
Oh, okay.
And explain that you have a chance of success. That's why they should give you, because it's an indulgence. You didn't abide by the time. So for them to condone, you must give them a bit more.
Okay.
And there must be a chance of success. Okay. Good. Right. Any other questions? Then we come to the execution of judgments, right? We've talked a bit about this, the sheriff going and attaching when we did interpleading just now. We did that. When the judgment is handed down by the court and the judgment debtor does not satisfy the judgment debt, you have a writ issued. Now, if you want to attach movables, you will have a writ issued. It's High Court Form 18. The sheriff then proceeds to the judgment debtor or place where his assets is, and he will demand satisfaction of the writ. If the judgment debt is paid in full, that is the end of the matter. If it is not paid, the sheriff will attach the movable property as is sufficient to satisfy the writ. Now, those of you who have seen the values that the sheriff give the property that they attach, it is far, in my opinion, far less of the value that the property is. But the sheriff will attach, he makes an inventory of the property and he takes the property into his custody. The goods is then sold at a public auction and the proceeds then goes to the judgment creditor to cover the debt. If there's any change, the change goes to the judgment debtor. If there's a shortfall, if the monies that are raised at the public auction doesn't cover the judgment debt, then the judgment debtor still owes that money. So that if the whole judgment debt is not satisfied, if it was for 1,000 rand and they only raised 400 rand, then he still owes the 600 rand to the judgment debtor. And like I said previously, it is valid for 30, the judgment is valid for 30 years. So they can come after you anytime in that 30 years, have a new writ issued if you don't have anything further, or they can go after your immovables if you don't have sufficient property, sufficient movable property. If they come back with what is nulla bona relaas, a nulla bona return, nulla bona return. There's no valuable assets. Then you can go to the attachment of immovables. Now, for the attachment of immovables, they've made, I think it was in 2018 when that amendment came into operation, where you can't just have property declared executable when you get a default judgment, especially in the case of mortgage bonds where people were in arrears with their mortgage bonds and then they claim the money that, not the money that you're in arrears, but the whole amount, because that is what the contract says. And then at the same time, they used to declare the property to be executable so that the sheriff can go and sell it at the public auction, also to try and cover the debt. And if the whole debt is not covered, there's still a debt outstanding. The court has now said that when the property to be declared executable is the primary residence of the judgment debtor, then there's a certain procedure that has to be followed before you can declare it executable. In terms of Rule 46, capital A, you must, that must be the last thing that you can do. You must look at other methods to recover the debt. Also, you must agree, the court must agree to a reserve price for the property, because in the past, remember, people used to sell houses for ridiculous prices and then the people still owed a lot of money to the debtors. So to avoid that, they agree on a reserve price that the property will be sold before the court will declare a primary residence to be executable, right? And then the sheriff will send a letter. This is how it is attached. The sheriff don't go and write up the house. He sends a letter to the judgment debtor is living in the property if it is a tenant, so that they know about it. And by that, the house is attached. Then there are certain duties that the sheriff and the attorney for the plaintiff must do. It must be advertised in the newspapers and it must lie at the magistrate's court. All of those things you can read in section 46, not section, rule 46 of the uniform rules, what they must do. And then the property is eventually sold by public auction. And like I say, there is a reserved price because that is what the court said. The property shouldn't be sold for less than whatever that is reserve price is. If it doesn't get that reserve price, then the people will find themselves back in court where they agree on a lesser reserve price. They will obviously have to convince the court about that. Okay, so that was my last slide. If you have any questions, please ask them now or forever hold your peace. Yes, Mr. Ali. And then Wilhelmina. Yes.
Council Abrams, I've got no further questions for you. I just want to say to you, thank you. It was very informative and I really enjoyed this lecture this week. Thank you very much. And I must say, maybe I'll see you soon in Boyson's court at the tribunal. Thanks.
Boyson's court at the tribunal. Okay, you're giving me clues as to what you're doing. Are you a magistrate?
No, not at all.
Okay. Okay. Yes, Wilhelmina. Vanessa.
It was a mistake. Sorry.
Okay.
Sorry about that.
Okay.
No problem. Just, if I may, just a quick question regarding the judgment debt. If it's not satisfied in full from a sale of movables in execution, does the outstanding debt run interest until it is eventually satisfied?
Yeah, it does. They do put interest on it, and then but the in duplum rule applies where interest can't be more than the value of the capital. Yeah, but interest can run. Yeah.
Thank you very much.
Okay, sure. Sindisiwe?
Hi, I also don't have a question, Advocate. I just want to say thank you so much for your patience this week. I've been attending all the lectures. I'm not comparing, but I must say it was one of the best for me because of your patience, because we're all not on the same level. Some of us are in completely different work roles and are doing this in a completely different field. And you've been very patient, and thank you so much.
Oh, it's my pleasure.
I concur.
Okay then. Thank you. It's 8:30 and you are now free on a Friday night. So you've worked on a Friday night. Other people don't work on a Friday night.
Thank
you.
Thank you, Advocate, for your patience.
Thank you so much. We appreciate you.
Thank you,
Okay.
Advocate.
Yeah.
Thank you so
Let me just
much.
hear Mr. Sabia. He has a question for me. Mr. Sabia, do you have a question? No, we don't. Okay. Okay, then I'll see you. See you in court. You won't know what I look like, and I don't know what you look like, but we'll see each other.
We
in
saw
court.
you on LinkedIn already.
Oh, okay. Oh, and you can see me on the Johannesburg bar as well.
So how can
we?
Yeah.
hear the voice?
Thank you very much.
Okay, thank you.
Thank you. Bye.
Bye. Bye.
Your contact, Advocate.
Thank you for the lecture, Council. Have a wonderful weekend and rest well, and good luck with your future cases.
Yes, you too. Thank you.
Your contact. Thank you, Advocate. I guess we are on your team. We'll meet on the case.
Is it? Okay.
Yes.
Oh, okay. When is that? Because I don't know when that is.
I think they say we're starting the 7th of August, if I'm not mistaken.
Oh, okay.
I'll have to change teams.
Thank you, Advocate.